prescribe is a reference to section 6A that provide for the establishment of the integrated electronic repository and certain directives that may be issued. The first definition, that is old definition that I want to discuss, is that of coercive behavior. Previously, it was discussed in the committee. I think the only remark that was made in respect thereof was to the extent that
sorry, Mr. Robertson, if you go back, yes, if you go back to the previous one of capture, are there any comments, members? Can we move to the next one?
Thank you, Mr. Chairperson. It's the definition of coercive behavior. Previously, there was a word in the first definition of coercive behavior. It's this one, to the effect that undue pressure must be exerted. We were requested to take that out. It has been taken out. The definition in option 2 was previously discussed in the committee. That still stands, and it reads, any abusive behavior towards a complainant that is intended to exert undue pressure on a complainant to act, not to act, or to be subject to certain acts against his or her will. A new definition is proposed under option 3, and this definition now provides that coercive behavior will entail compelling or forcing a complainant to abstain from doing anything that he or she has a lawful right to do, or to do anything that he or she has a lawful right to abstain from doing. Going to stop there for any comment. Must I go? Let me deal with option 4 as well. Option 4, we're currently an option that was presented to the committee. We decided to delete this option due to the fact that this almost amounts to intimidation of some sort. It's more severe than coercive behavior, and definition under option 3 is the new proposed definition in the place of option 4. I'm going to stop there.
Can you show both of them so that we're able to compare them? Option 2 and option 3. Can you just go down a bit?
Okay, that was option 4. It was previously option 3.
Yeah, can you go up? Want to see option 2 and yes, option 2 and option 3 together, yeah. So with these two options, substantively, what is the difference?
It's mainly the wording. It is basically the same. It's merely drafting. In the first one, it's certain behavior towards a complainant that brings about the intended result. The second definition is more polished. And it just means to compel or force a complainant to do anything that will amount to coercive behavior. In essence, it's a polishing of drafting of the definition that is already in it. The department, our preferred option will be option 3 here. And then obviously option 4 is omitted.
Members, no comments?
Chairperson.
Namfuke?
Thank you very much. I think I agree with option 3. It's actually polished and more detailed. Thank you very much.
Thank you very much. Honorable Breitenbach?
Agreed.
Agreed. Thank you. Honorable Swart.
Chair, I do also tend to agree. I just want to make the point that it's incredibly broad, this definition as pertaining to behavior, and we also deal with the catch-all later as well, Jay. I just wanted to make that point, but it's very broad, and I think it's necessary. Thank you.
Okay, thank you very much. Can you go to the next one? So for now, we are fine with option 3.
Thank you, Mr. Chairperson. The next definition is that of controlling behavior. Option 1 is the current definition that is in the bill. The new definition that was proposed and previously discussed is that of the second option, and that is defined as behavior towards a complainant that makes him or her subservient or dependent to the respondent, and it's all inclusive, including isolating him from support, depriving him of means, of independence, resistance to escape, or to regulate his or her every behavior. Again, I must point out that it's mainly a drafting amendment that is proposed. According to the drafters or the group that work on the bill, option 2 would be the more appropriate option. It's also in line with the legislation, amongst others, of the Australian territories in their domestic violence bills, as well as other definitions and other legislation elsewhere. I'm going to stop there then.
Okay, members. Honorable Breitenbach, is it an old hand or a new hand?
Old hand, sorry.
Okay, thank you. Are there any comments, members? I will take it that members, for now, we are not making definite decision, but for now we are happy with the proposal, option 2. We will still, that does not mean that members, upon deeper reflection, will not come back and raise other issues. Let's go to the new one, to the next one. New
Sorry,
definition.
Mr. Chairperson. Yes, the new definition that was inserted is that of communication. It was previously discussed, and it mainly relates to harassment, and the communication intended here is anything that is not in electronic form, like letters, text, photos, video, audio recordings, etc., that is shared during an instance of harassment. And then also definition of the Criminal Procedure Act is proposed, which most of the people, the honourable members, previously agreed with. So it's mainly the definition of communication that needs to be considered. Thank you.
Okay, members. There's no one.
The person, my hand is up.
Oh, sorry, Honorable Mfuke.
Chair, I think on this issue, I just want to find out on communication means anything that is used to impart information. How are we going to work on this? Because I can tell you that 2 days ago, I've been getting funny messages, text, nude, and everything. And when the police were checking on this from these strange numbers, they found that those numbers, the 3 of them, are not registered. Then I'm asking myself, this problem is going to continue, because they were saying these are those that are coming from whatever shops and all that. And my question was, Are we going to be able to deal with these people that are harassing people or not? And I don't know, maybe there's another mechanism, maybe Mr. Robertson, you can assist us, because I'm talking about something that happened 2 days ago, and the police reported to me this morning.
Mr. Robertson, is that not covered under electronic communications?
That's correct, Mr. Chairperson. It is covered under electronic communications, and it relates to the new proposals regarding electronic harassment, which I will discuss at a later stage. And I also then deal with the question of the honourable member. Thank you.
Are you covered, Honourable Mpuke?
I think it's okay, because I thought I must raise it here before we go further, because
Okay.
the challenge is that we can have good laws, but implementation can be a problem.
Yes, yes. I must, before I note Honourable Jale, I must also, I'm advised that Ms. Petronella Lenders from Department of Communication and Digital Technologies is also here. Maybe if you want to say something on issues regarding communication and telecommunication, Ms. Lenders, you are free to come in at any point.
Thank you, Chair.
Thank you very much. Honorable Jale.
Thank you, Chairperson. I just want to find out if maybe this video recording, it covers the issue, sorry, the issue whereby you find somebody, you know, young people, they normally, okay, you were having a relationship with this person, and he decided that he maybe during your time you took some videos of yourselves with those, you know, some of unbecoming, you know, actions or things that you normally do. So you find that after maybe you feel that you are no longer interested, and this person will take these videos and take them to public just for harassment. Is that what does it mean? I just want to find out. Is this communication covers that?
Mr. Lawrence, Ms. Robertson.
Mr. Chairperson, let me first try to finalize communications, electronic communications and harassment, and then I will discuss all the questions. But yes, communication here will cover something like an intimate image that is recorded. And insofar as it relates to domestic violence caused by harassment, we need to take into account first the definition of electronic communication. Electronic communication, the preferred option is the second option, reads basically the same, means electronic representation of information in any form, which include, amongst others, videos, animated images, visual images, etc., that is disclosed by means of electronic communication. So it's the two kinds of communications that is relevant here. First, your communications in the real world, and secondly, your communications in cyberspace. The conduct that can be committed, or which is regarded as domestic violence, is that of harassment. So in terms of the conduct that is prescribed as harassment, the making available of both communications in the real world to another person, or electronic communications to another person, that is a person other than a complainant, and even the complainant herself, may amount to harassment and therefore constitute domestic violence. And the requirements therefore is, amongst others, that the information so disclosed must be information of a private nature. It must be information that violates or offends the sexual integrity or dignity of the complainant. The communications must be something of abusive, degrading, offensive, or humiliating nature, or it must inspire belief in the complainant that he or she or a related person may be harmed. I will come back to harassment as conduct that constitute domestic violence. Regarding the concern that has been raised, that there is communications that is being distributed and where you cannot trace the person who sent that message. One must first realize there's different ways of sending electronic communication. The tracing of a communication via a cell phone is subject, amongst others, to the Regulation of Interception of Communications and Communication-Related Act. In terms of Section 40 of the RICA, there's obligations on service providers to record and store information of customers that buys a SIM card and activates it on the system. So the electronic communication service provider has got a legal obligation to obtain that information and store it on their systems. And this can be used to trace, let's say, a SMS that was sent. But yes, we do realize there's problems that there's various SIM cards that is out there that has not been RICA or properly been RICA'd, and that there is a possibility that you cannot trace each and every person. On the other hand, there's also information that can be submitted via the internet. Section 39 of the RICA places similar obligations on electronic communication service providers, namely that if a person applies for a service, that service provider must obtain all the necessary particulars from such a client and record and store it. The issue that was previously raised mainly relate to information where a SIM card is involved. In other instances, amongst others, where there's a fixed line or ordinary old telephone or internet, that information can, to extent, readily be obtained from the service providers. And I will discuss a provision later on in the bill, which was previously discussed, and make provision that the court can request electronic communication service provider to assist to obtain the necessary particulars to identify the respondent or other person who sent a malicious communication. It amounts, in terms of the other section, court must issue a direction to electronic communication service provider. The electronic communication service provider must then, in his archives, identify the person who sent the message and the particulars that's available to a person who sent that message. So to an extent, it does address the concern that the RICA mechanisms can to extent be used, at least to trace some of the people. But yes, we do realize there is instances where there's illegally RICA'd SIM cards out there. We're currently busy with the revision of the RICA, amongst others, and during that revision of the RICA, a more secure process will be developed to ensure that all the information of persons that use electronic communication service will be recorded and stored by electronic communication service provider. So to a large extent, this mechanism may be dependent on other legislation, but yes, there is legislation in place that do provide for relief in the interim. Thank you.
Thank you very much, Honorable Nevot Dragan.
Thank you, Chair. Perhaps Mr. Robertson can answer me when he moves on to the electronic communication section of the Act. So I'd just like to follow up right now on what Honorable Jele raised, what Honorable Mufokeng raised about the phone numbers that are untraceable and they're sending messages. So what about places like internet cafes or those computer shops? So are you saying that those kind of internet cafes and their computers should be registered as well? Because I guess they don't use SIM cards, but you can send inappropriate messages using internet cafes, and there's so many people who use the cafes that you cannot trace a particular individual. But I can wait for you to cover that under electronic communications. Thank you, Chair.
Sorry. Thank you very much. I think there might be some assistance from DCT, Ms. Linders.
Thank you, Chair. I just wanted to respond to say that in terms of computers and internet cafes, every computer has an internet protocol and IP address. So any computer where any information that is sent over a computer can be traced in that manner. It's not the same as a mobile phone, but I think Mr. Robertson would probably address that as well when he goes into the issues relating to electronic communications. But I just wanted to note that computers are traceable through their IP addresses, and therefore those would be traceable. But I think we would also take note of the comment from the honourable member around how do we work around looking at the registration of those and speak to internet service providers in that regard. Thank you.
Thank you. But Ms. Lenders, I think the issue would be that you would be able to trace the computer where this issue came from, but you might find that in that computer for that particular day, maybe 5 or 6 people use that computer from an internet cafe.
Chair,
yes.
Before she comes in, can I add something also on what you said?
Yes, Honorable Taylor.
Yes, I think also even the telephone, the internet cafe telephones, sometimes it might be a problem because even if it's registered, the people that are coming there are they registered that maybe at a certain time this person called and this one called? Because I think that can also cause a problem, can be a challenge. Thank you, Chair.
Thank you very much, Ms. Linders. We know that
maybe before she answers,
okay,
can I ask a question? Can I ask a question so that she can answer also on that one? I want to know that what is the responsibility of Department of Communications in terms of the mushrooming new telephone shops, and they will be owned by foreigners? Are they also doing the same? Because a person will tell you that if they steal your phone, they can go and clean it up there. That's where the problem starts. Well, the police are doing their best. They are trying very hard, but they will tell you that in a day with their grabber, how many are they? That is where the problem is. And the question is, do we do enough on monitoring and looking at who opens up shops like that?
Thank you very much, Ms. Mfoke. Ms. Linders.
Thank you, Chair. I think firstly, in terms of the telephone question, if it is a mobile phone, then it would be the same as what Mr. Robertson responded in terms of RICA. If it's a landline, that would be a little bit more challenging because it would be traceable as per the telephone conversation rather than the actual handset. Then with regards to the mushrooming of shops, I think as the department, we are obviously not directly responsible because business and economic activity is the responsibility of the Department of Trade and Competition. However, we do take note of the concern that has been raised by the committee member, and we will engage the Department of Trade and Competition around, and as well as small business in terms of looking into this matter, because it is definitely a concern in the context that it is what contributes to the illegal activity as far as SIM cards are also concerned, which then creates some of the challenges that was raised about America. So it is not a direct, in the direct mandate of the department to monitor the opening of the shops, but obviously when it comes to the electronic devices and processes, that is part of our mandate and we would need to look into that. For now, that would be my response, but I will definitely take it back to the department as well.
Ms. Linders, don't you think that part of the challenge is just to look at the departments from the economic cluster? Because some of these issues are issues of cybersecurity. Don't you think that you would need to consult much more broadly in dealing with this matter, the police, the SSA, because I think it's a government, it's a state problem that would need a comprehensive response. I think let us not lock it into fewer departments that I think it's a security, it's an economic, it's a social issue. So I think it needs a comprehensive response from government, also looking at developments in technology that are there. Because part of the challenge is that criminals in certain instances are using far much more advanced technologies than the state has.
I absolutely agree, Chair, and in that regard, the department is in the process of concluding the digital economy master plan. And in that master plan, some of these issues are being addressed, and there is a stakeholder process around that. So I think this is one of the things that I will also take back to that process in terms of including it in there, because the digital economy master plan is being discussed in the economic cluster as part of the response of the department to look at the new technologies and how digital technologies can be utilized within the economic space. So I think this matter would then definitely be taken up as part of that. And I definitely agree that it is a government-wide response that is needed.
Thank you very much. I don't think that you have the same problems as all of us. You are from telecommunications, so I don't think that you've got low bandwidth. So it will be important that we see you. Ms. Linders?
I have opened my video, Chair. I'm not sure if you can see me.
Not properly, but work on it. I think the next time you speak, we can't see you properly. the next time you speak, I think you should open the video so that people can see you, so that the promises you make here, we can be able to identify you when we meet you in the streets. Okay, Mr. Robertson, let's proceed.
Thank you, Mr. Chairperson. Let me.
Apologies, Chair. Honourable Druchlin has a hand raised.
Okay, Honourable Nibo Druchlin.
Thank you, Chair. I just wanted to ensure that Ms. Linders had covered. I'm not sure if Ms. Linders had covered everything that we had raised, so I waited for her to finish. So what I wanted to say is that, you know, we trying our best in these three bills to cover all the bases, and you know what, Ms. Linders, as part of the department, what she says that, you know, it's not part of the department's mandate, and we do understand that each department has its own mandate, but many things are happening out there, and they happen really quickly, you know, and it contributes to the abuse that women face. So we need the departments to help us speedily and to all be involved speedily and to put more effort into it. So we can only cover as much as we can, and we're trying to cover all the loopholes that can possibly be available, but we do need that strong assistance from the departments.
Thank you very much, Honourable Nibo Druchlin. Ms. Linders, do you want to comment on that?
Thank you, Chair. I'm not sure if you can see me. I did switch on the video now again. Just to indicate that I would like to just apologize that I did not necessarily mean that the department will not deal with the matter. I was just indicating that from a perspective of the direct, or rather the lead department, is not necessarily DCDT, but in terms of the department itself, we do understand that we have to work in an integrated manner as government, and as a result, all government departments has a responsibility to assist with implementing these bills, and therefore just to indicate that we as DCDT has the digital economic master plan as one of the areas where these matters can be addressed, but we also have the Film and Publication Board as an agency of the department that specifically deals with the issues from the perspective of children, and I will also make sure that we raise the matters with the FPB around this as well, especially in terms of the tracking of information or tracing of information as it pertains to mobile phones and computers. And then lastly, from the department's point of view, we are also responsible obviously for the licensing of cell phone operators, and we would then also have a discussion with ICASA in terms of the issues that was raised today. But just to note that, as Mr. Robertson has explained it, and the amendments that is proposed, it is going to strengthen this matter of harassment online, because currently in the South African context, it is mostly children that are protected by virtue of the legislation, and adults, especially women, are not necessarily as protected due to some of the shortcomings in the legislation, and therefore these amendments to the domestic violence bill will definitely enable women to be more protected in the online space as well. And we would obviously just have to look at how do we strengthen the implementation of these amendments once they become law.
Thank you very much, Ms. Linders. Thank you for that date. Mr. Robertson.
Mr. Chairperson, if I may just say something more in relation to online harassment. Yes, the problem with internet cafes is that you cannot place a person behind a computer. It's like all cybercrime. You can trace the crime directly to a computer, but who or five people were behind the keyboard, they used the keyboard, is usually problematic. So yes, it's problematic per se. And then you also get something like virtual IP addresses that can be created. You get software that can be used to mask an IP address, so it's difficult then to trace such a person. And also various cafes, etc., do provide free internet services. And if you log on to their service, it's problematic, amongst others, to trace such a person. Regarding the distribution of cell phones, it can be addressed through an amendment to the effect that a person must report a stolen cell phone and that such cell phone must then be permanently deactivated. So you cannot use it further on the system. A cell phone has got integrated electronic address, and if that address is blocked, you cannot use it nowhere on any cell phone network in South Africa unless you tamper with that phone. Regarding possible interventions to address internet cafes, some countries elsewhere in the world do require that such people must, amongst others, obtain records of persons that use a computer. Such obligations do not exist in terms of any legislation in South Africa. One must also take into account that internet cafes is usually people that don't actually make a lot of money, and additional obligations on them may be problematic in the long run. Thank you. I will continue then with the further definitions. A further definition, the current definition of damage of property was previously discussed in the committee. The second definition of damage of property was also discussed. Some of the, let's call it, differentiations between the first definition and this one.
Before you proceed, Mr. Robertson, Ms. Clark wanted to say something.
Thank you, Ms. Chair.
Good afternoon, Chairperson. It was just firstly to confirm what Mr. Robertson has said, but just to say from the perspective of the investigation that we're involved in at the Law Reform Commission on pornography and children, what they're doing in police investigations at internet cafes is that the police are using the video or the CCTV cameras to place a person behind a computer at a particular time. And that is how they're doing the investigations in that regard. So I thought I would just add that to the conversation if it assists. Thank you, sir.
Thank you very much. Thank you very much, Ms. Clark. Thank you very much. We note that. Mr. Robertson.
Thank you, Mr. Chairperson. Then back to the definition of damage to property. It differs, amongst others, from the first definition that in terms of this definition, it is included that any damage of property in close vicinity of a complainant or a related person that causes harm must be regarded as damage of property. We did previously indicate that the destruction of such property may probably be better accommodated under emotional and psychological harm. And I think paragraph B and C is self-explanatory, mainly where you damage property, but where you damage property or you threat the damage to property, paragraph B is more or less in line with the current definition in the bill. And then under this definition, the harming or threats to harm a household pet or other animal belonging to a complainant or related person is included under damage to property. The other option is to include both paragraph A and C under emotional or psychological harm, as we have done. A better proper, or the third option that was proposed is mainly the same as the first one, but includes threats of damage or destruction to property, and then we require that it must inspire harm. The preferred option is option 4. It was also previously discussed in the committee, and according to us, the fourth option is probably the way to go. And in terms of this, it's the damage or destruction of property, threats to damage and destruction of property belonging to, which in the possession of, or under control of a complainant, or in which a complainant has a vested interest. So it's all encompassing a definition, the fourth one, minus obviously conduct that may amount to emotional abuse, as in the previous definition. So option 4, according to the department, is the better option to follow. Thank you.
Thank you. I remember Honorable Jelle had an interest on this clause. I'm not sure whether she is covered now. But in the meantime, let me note Honorable Swart, followed by Honorable Nieuwoudt-Drachen.
Thank you, Chair. I like this definition, option 4. I think it's broad enough. I'm thinking of the situation of clothing as well in domestic violence, as tragic as these occur, but where people, women might be assaulted, and clothing, and I would read in that would cover all types of property, or the vehicle that you're driving in, or your household furniture. I think that it does cover, it's a good option. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Nieuwoudt-Drachen.
Thank you, Chair. Thank you, Chair. I prefer option 2 because it includes psychological and emotional and psychological harm. And it's because many of the abusers or victims do not can experience non-physical types of abuse. So, the psychological and emotional abuse will not show unless they speak about it. And, as that is an experience of women, I feel, I'm in support of option 2 because it makes reference to that. Thank you, Chair.
Thank you. Honorable Jelle.
Chair, I think I was going to go with option 4. I think because of because I'm covered on option 4. But what Honorable Nieuwoudt is raising, I think it's a point, because I was also thinking about that, though I didn't know where it's supposed to feature the issue of name calling. I'm not sure if, because that one can also fall on that, it has to come to the psychological and emotional definition somewhere. But because of she feels that she's the second one also covered, because it's not covered here in terms of emotional abuse on option 4. Oh, am I confusing you, Chair?
No.
Okay. So option 4, for me, it covers me from previous discussion on the last sentence where it says, oh, which the complainant has a vested interest. I'm covered. But now I think I would want to support Honorable Velma with the second one, because this one, it doesn't talk about anything about emotional, because indeed there are lots of things that are happening, including name calling. Women are just subjected to name calling. So maybe Mr. Robert can tell us also, maybe we can revisit and talk about that. Where does it feature also when it comes to emotional and psychological? That one, I'm talking about something different now, name calling.
Okay, Honorable Wittenbach.
Thank you, Mr. Chair. I'm reasonably happy with option 4. I do hear what Honourable Neva Drachen is saying. Perhaps we can just have another look at number 2 and do some comparisons. Otherwise, perhaps Mr. Roberts can just tell us where in the bill, and I'm sure it is somewhere, psychological and emotional abuse is dealt with.
Okay, Mr. Roberts, is there anywhere in the bill where we deal with psychological and emotional?
Yes, Mr. Chairperson, there is a clause that specifically deal with this conduct, where, which regard emotional, verbal and psychological abuse as instance of a domestic violence. I will discuss it later on. In that definition, the aspects of damage to property that cause emotional or psychological harm is dealt with. So it's not necessary to include it under damage to property. We're trying to clear the conduct up into compartments to ensure that certain conduct doesn't overflow into other conduct. And that is why we decided for a clearer definition, amongst others, for damage to property. But any other conduct that involves damage to property, but could cause any other harm, is dealt with, amongst others, under the conduct that relates to emotional, verbal, and psychological abuse. I will discuss that later. Thank you.
Thank you. Honorable Neva Drachen, with that explanation, are you still protesting that we should opt for option 2?
No, Chair. I'll hold that point until we get to the point as explained by Mr. Roberts. So as he said, it's still coming. I'll read that part first, and then, but for now, it's okay. Option 4 is fine.
Okay, thank you. Honorable Maseko Jale.
Are you
still supporting the withdrawn protestation?
Yeah, I'm supporting option 4, Chairperson, and then I'll also go with her to that point. I'll be with Honorable Velma also there.
Okay, thank you very much. Ms. Clark, you raised your hand. Are you covered now?
Yes, thank you, sir. All I was wanting to just to say was that what the definition does is not only clears the conduct, but it also creates an easier way of proof of what has happened. So you only have to objectively prove that there was willful damaging of property. You don't have to, in addition, prove that there was damage to the property and you were emotionally harmed or psychologically harmed by it. So it makes the entrance to being able to apply for the protection order easier on that ground.
Okay, so we will revisit it, option 4, if members are not covered under a psychological and emotional definition. Let's proceed.
Sorry, Chair.
Honorable Swart.
Chair, I think we just need to bear in mind, and it's not easy to follow because this is electronic, but that we are basically still dealing with the definition of domestic violence and the different categories under that. So damage to property would fall under the definition of domestic violence. And so once you see the broader picture, I think one loses it electronically, but this is part of the definition of domestic violence. And just because the definitions are alphabetical, it actually comes down later, where you will see definition of domestic violence includes damage to property, emotional, verbal, and I think that's where I also struggled a bit to follow, and this is how we normally do it, but I think it's old school. It's easier where you've got a hard copy where you're looking backwards and forwards, but I appreciate this is how we're doing it. So just to say that we are dealing with sub-definitions of definitions. Thank you.
Okay. No, thank you very much. Can we proceed, Mr. Robertson?
Thank you, Mr. Chairperson. The next definition to be discussed is that of disclose. The definition of disclose, was previously part of clause 5B that deals with electronic communications. Due to the fact that harassment is redefined or re-provided for, and there's a reference to disclose, it's necessary to include that in Section 1 of the Domestic Violence Act. The definition is similar to that was previously discussed under the proposed Section 5B of the Domestic Violence Act that deals with the obligations of electronic communication service providers to provide information to the court. Disclose can be discussed at this stage merely to say that it doesn't merely include this transmission of electronic message to a person, but it also includes, amongst others, where you store it elsewhere, where it can be accessed by another person, or where you make a link available to such message where it can be downloaded, viewed and seen by other person. But it was previously discussed. I'm going to continue.
There was just an error there. Can I just send sorry, Chair?
Yes, I was noting you. Honorable Swart.
Send the electronic. There's a word missing there.
That's correct.
Communication.
Yeah, it's already cleared up in the other version that was prepared. Thank you, Mr. Swart.
Thank you very much. Before we proceed, members, I just think that we have to agree on one housekeeping rule. I think it would be important for us to agree at what time do we adjourn, because it would also be counterproductive to have a situation where members push themselves and make serious decisions that would have serious impact on the lives of our people, when people are just tired and they're just pushing just to finish, to get by. So I think it would be important that we push and we agree on what time do we end, and then for whatever it's left, we can still come back to it. But we must make these decisions being sober, not being just complying, but we must ensure that these decisions are not the easiest decisions to make. So I would suggest that we agree on the time that we will conclude today, and then whatever is left, then we will have to come back at a date that we will circulate to all members. Honorable Chair.
No, Chair, I think it's the old one.
Members, can we, because it's very easy to raise and to lower your hand, can we always lower our hands immediately after we speak? Or if we don't do that, can the Secretariat assist us to immediately after the member has spoken, just lower his or her hand? Honorable Mufokeng.
Thank you, Chairperson. I want to suggest that we actually planned on 7 o'clock, But due to the load shedding for a number of members, I don't know if they will agree that we go until 6 o'clock or 6:30.
There's a proposal for 6:30. Honorable Swart.
I think 6 p.m. might be advisable. Some of us have to prepare for debates for tomorrow morning as well. And we've also got challenges in that regard. And given the fact that the urgency has fallen away to a certain degree, maybe we should look at 6 p.m.
Honorable Jala, will you be violently opposed to that difference of 30 minutes?
No, Chair, I'm fine. 6 o'clock is fine.
No, sorry, Honorable Mfuteng, sorry, my mistake, Honorable. Was Honorable. Honorable, okay.
No, Chair, I think I said 6 or 6:30, so I will go back to support the Honorable Swart, noting that it has been a long day for a lot of members.
Yes, a long day and a long week and a long month. Honorable Nibo Trache.
Thank you, Chair. I will normally follow my whip, but I'm glad that the whip converted back to 6 because I do have to think of the sign language interpreters as well. It has been a very, very long day and a long week, and there's more coming. So if it's 6, I'll accept 6. Thank you, Chair.
So members who will adjourn at 6 o'clock. Mr. Robertson.
Thank you, Mr. Chairperson. I'll continue then with the definition of disability. There's 2 options proposed, and that was as a result of comments that we did receive. The second option defines disability with reference to the Mental Health Care Act, and it's defined there as a mental illness or severe profound mental disability, which makes a person incapable of making an informed decision or giving lawful consent. This is obviously probably a better definition as the first one, and there was previously some objections raised in respect of mental disease, etc., but we omit that from the bill. Thank you.
Thank you very much, Honorable Nibo Trache.
Thank you, Chair. Chair, I'm disappointed to see option 2 is still there because that definition means that me, as a deaf person, has a mental disability. That's what that definition essentially means. It should really say mental disability means etc., etc. So it should. But I also went through the Mental Health Care Act last night, and nowhere in that act does it say disability means mental illness. It doesn't say that. And also we need to take in consideration the difference between a mental disability and a mental illness. Those are 2 separate things. So really, option 2 really needs to be removed. It should be, and we need to follow option 1. I'm very disappointed to see that option 2 is still there because it means that Petronella, who is partially sighted, has a mental disability as well. That's what this definition means, and we can't have that definition there. No, sorry, Chair.
Thank you very much, Honorable Jala.
Indeed, Chair. I want to support Honorable Nibo Trache on this one. I think I'm sure we can consider having 2 different definitions on that one. I'm not sure, like she's putting it, disability can be mental illness because one can be disabled in another way, not only mentally and all that. I see here a severe profound, but I agree with her, Chair. Thank you.
Thank you very much, Honorable Breitenbach.
Thank you, Mr. Chair. Yes, I must agree. This option 2 is profoundly insensitive, and it cannot.
Yeah, even the dog doesn't agree with it.
My dog's very upset with this option 2. Very.
I expect
Yeah, and that dog is consistent in attending meetings.
My dog is very conscientious.
So we have all the members disagreeing with this option 2, plus the dog. So, Mr. Roberts, can you rework and bring back something better?
Mr. Chairperson, I will do that. Thank you.
And please consult also with the dog.
Yes, the dog is very important.
The dog is available at any time for consultations.
Yeah, please consult. Mr. Roberts will, on a serious note, will rework and bring a better option. Can we move to the next one?
Thank you, Mr. Chairperson. The next definition relates to domestic relationship. And it mainly relates to paragraph F. In terms of section 1 of the Domestic Violence Act, complainant is a person that is in a domestic relationship with a respondent, and she can apply for a domestic violence interdict if domestic violence is committed against her. The only real thing here that was previously amended in the bill relates to the sharing of property, where the complainant and respondent shared the same property. The first option removed the recency requirement. The second option that is proposed is to more or less restrict the definition to some extent to persons that is either in a domestic or a family relationship through the words are persons in a close relationship that shared the same reasons. It was previously explained, amongst others, that persons living in a men's dorm
Mr. Roberts, can you unmute yourself? Mr. Roberts?
Mr. Chairperson, can you hear me?
Yes, now you are.
Mr. Chairperson?
Yes, we can hear you now. You're muted. We thought that you ran away from the dog.
Mr. Chairperson?
Yes, we can hear you.
Hey.
Can hear you. You have flu.
Mr. Chairperson?
Yes, we can hear you.
Hello? Hello?
Hello?
Hello?
Yes, we can hear you, Mr. Roberts. We keep on unmuting yourself.
Hello, can you hear me?
Yes.
Can you hear me?
Yes.
Sorry, Mr. Chairperson, it's not per se muting, it's like something went wrong. Sorry, let me re-explain then.
We thought that you ran away from the dog.
No, I'm sure I can phase him. I'll re-explain paragraph F. The second option is merely to restrict the wide ambit of a domestic relationship, where it only requires that persons share the same residence. Obviously, people in the men's dorm at university may share the same residence, or people that's in the army or the navy, etc. So the mechanism that is used is the words "are persons in a close relationship," and that is defined elsewhere, and I'll discuss that later on. Thank you.
Thank you, members. Honorable Jale, is that a new hand?
Yes, it's a new hand, Chair. I think he covered me, Mr. Robert covered me a little when he was explaining this, because this, Chair, to me, I wanted, remember as we were talking about the spiritual abuse last time, but I'm not there. I wanted to bring this one to the issue of residence.
Yes.
Yes, so it means it covers me on that part of the one that I was talking about, that these people who are sharing a residence, especially when they go and have training on the issues of when they go, like culturally, Chair. When they go there, I don't want to say, because we are not going to discriminate, we are just going to look into all the areas in order to make this one broad. In the African culture, they talk about izangoma, where they are trained. I did talk about the issue of the abuse that is happening there. You might have a belief in that area or not, but there is something happening. So does it cover that residence also? Because people are moved from their homes and taken to this place for training. I thought the issue of when Mr. Robertson was mentioning the issue of the soldier, you know, where the soldiers are staying, maybe that will cover me. But I want to make sure that when you talk about residence, we are referring to even temporal residents. Those people are there for some times, like they are there for training, and something happens there, and they get abused and all that. They are covered. That's what I wanted to know, Chair. Thank you.
Thank you very much, Mr. Robertson.
Mr. Chairperson, if we use the paragraph F, there must be a close relationship nexus between the persons. If we use the current the definition in option 1, it will apply to such persons to the extent that they merely have to stay together and at the same residence, then they will be regarded as complainant and respondent for purposes of a domestic relationship. The second one requires the additional requirement of people in a close relationship. Concerning the question that was asked, residence is redefined. I'll discuss it later on. But if people are not in a close relationship and taken away to some other place, they may fall outside paragraph F of the definition of domestic relationship.
Honorable Breidenbach.
Thank you, Mr. Chair. I listened carefully to Honorable Jenny. The difficulty is here, in my view, we're busy with legislation that deals with domestic violence. And as soon as you start including any kind of close physical proximity living arrangement, that isn't necessarily a domestic relationship. There are other acts, but other provisions, statutory and common law, that deal with assault, kidnapping, those offences that don't require a close domestic relationship. But what we're dealing with here is domestic violence, and that presupposes some sort of relationship, some relationship. Otherwise, it's not domestic violence, it's just violence. Thank you.
So for you, the paragraph F is important.
Yeah, I would think so, because it brings it into the stable of domestic violence. We must not lose sight of the fact that we're not dealing with all gender-based violence. We're dealing with domestic violence. There are other provisions that in other legislation and in the common law that deal with just ordinary violence against women that isn't domestic in nature.
Yes.
So yeah, F is good for me.
Thank you very much, Honorable Nivo Drachan.
My hand is
Thank
still
you,
on.
Chair. Thank you, Chair. What Honorable Jele just said, I just wanted to ask Mr. Robertson. Is it covered somewhere else where people are living at schools, for example, boarding schools like hostels? You know, when during the term, they don't go home, but they're there in the hostels, and then holidays they go home. So if something like that happens there, you know, that kind of thing, you know, I know it's domestic violence, but how is that then covered? How does it cover them?
Thank you very much, Honorable Mufokeng. Then we'll be followed by Honorable Jele.
Thank you, Chair. I think I also will agree with this, but the question will be this recently. I will be happy with that share or shared the same resident, because a person can share with you and go out and come back to do something, but that person shared with you and a resident. Otherwise, I'll be happy with that. I thought maybe Mr. Robertson will explain the recently, but otherwise it's quite fine for me.
Sorry, Honorable Jele.
No, thank you, Chair. I think the mistake that I did when I was explaining that is like people are taken there. No, it's not like people are forced. People go to these places voluntarily. Nobody's forcing them. I think the example that has been made by Honorable Nivo covered me, but even the very same F, the sentence there, it covers me without that recently as Honorable, because it says here close relationship, because those people that I'm talking about, there is a close relationship. It's like a chairperson, the very same example of saying this person goes to school for training, like Honorable Nivo was saying. They go to school for some times, but they come back. They go there voluntarily. It's not, there's no violence. They because, you know, this thing, I want it, Chairperson, my view is that it should cover both. We have a background as South Africans. All the sectors must be covered by this that we are doing here, because it cannot be only the issue of saying only those people who are in that house, that residence. Every residence, this resident must include every residence, whether it is at school, but I know definition of residence when now it gets out of, maybe I will talk something else, but this residence, it must tell us, it should be the resident that I understand it is. So I'm saying it covers me the way it is, because these people, they have a close relationship. There is a close relationship. One, there is a same residence. So it covers me, unless maybe, because I know Mr. Robinson cannot understand it the way we understand it as the people coming from that culture. Thank you, Chair. I understand, but I'm covered with this F.
So you are covered with this F, but I think we need to ensure that ourselves and Mr. Roberts understand the same issues. There was a point raised earlier on that whatever we do, but we must ensure that it is within the domestic violence.
Yes, Chair, I agree.
So whatever we want, it must not be outside of the domestic violence. So members, the F, in fact, F as it is written here, which includes a close relationship, does it cover all of us?
Yes.
There's no dissension. Okay.
Swartja, sorry.
Honorable Swart.
Should we not also ask Mr. Robertson to start marking preferred choices where, so that he knows options just at this stage, like it's been done with our other legislation, just where you just indicate today's date preferred option, so that also helps him. That could be something to be helpful with. Thank you, Chair.
Well, that's fine, but so far there has not been. We have been one in terms of agreements, in terms of the options, but he must opt for something that will be able to remind him.
Yes, yes. I'm just reminded how we dealt with the other legislation where we went through different options in one suite, basically, and it's not binding, but it just gives an indication, so we don't have to come back to the issues and reopen the issues. That might be just helpful for us, but it's up to you, Chair, and the members.
Okay. Oh, that's fine.
Okay.
Before Honorable Jale, I just thought that as much as we are making some form of decisions, but there will be nothing stopping us from revisiting if something, for instance, a member comes across something that he or she thinks that it triggers certain issues in his or her mind. She might want us to revisit before we adopt. But for now, it is tentative decisions, which if nothing comes, which is different, we will take it as a decision of the committee. But Mr. Roberts, please ensure that you track the preferred options as we adopt them. But there'll be nothing stopping members from saying that I thought about something in that option. Can we relook at it? Honorable Jala.
Thank you, Chair. I just wanted to say Mr. Robertson should not forget to remove that recently that Honorable Mfokeng spoke about, because when you cover it like this with one color, maybe he will forget. So this one must be different, so that you know that we agreed on this one without this recently. Thank you, Chair.
Thank you. I think it is in line with what Honorable Swart was saying. Mr. Roberts, you must track them in a manner in which they are covered each day, so that you are able to guide our decision-making process. Okay, can we go to the next one?
Thank you, Mr. Chairperson. Just to indicate, recently is deleted. It's in square brackets. The next one relates to the definition of domestic violence. New conduct that is defined as domestic violence that have been included for consideration is that of sexual harassment. Sexual harassment was previously under the definition of harassment. Well, the draft has decided it's probably better to deal with sexual harassment separately. So if I now insert sexual harassment in the definition of domestic violence, a new definition that's also inserted relates to that of a related person abuse. Previously, related person abuse was covered in the various definitions, which make it very difficult. I did explain it previously, that it actually allows a complainant to apply on behalf of other person or related person that was being abused. And to deal with that, specific conduct is now regarded as related person abuse. The other amendment is that to paragraph HD that relates to exposing children to certain forms of domestic violence. During the public consultation process, we were requested to ensure that intentionally must be inserted due to the fact that it's obvious if a person does not willingly expose children to the conduct in question, it should not fall within this category of conduct. It's amongst others where two people live together and one hits another, then both people can actually be regarded as having been committed an act of domestic violence. Paragraph J is a further amendment. Paragraph J is a catch-all provision that deals with any other form of harm or domestic violence. And wording that is proposed currently has been amended. The first option is any other behavior where such behavior inspires harm or a reasonable belief that harm may be caused to the complainant. The second option, amend paragraph J and require a reasonable person test to say that a reasonable person must regard the behavior as behavior that inspire harm or cause reasonable harm. The third option is without the test of a reasonable person, but it do correct a drafting error in the bill. Previously, if one look at the definition of domestic violence, all the conduct in paragraph A to J was subject to a clause that tells you such conduct must cause harm. It's that wording. So harm were previously included in all the various conduct that amounts to domestic violence. If paragraph J is followed, it's further qualified here, amongst others, by the words inspires the reasonable belief that harm may be caused to a complainant. So it's basically three options. First is the option that merely say anything that may be done to a complainant that cause harm to a complainant or a related person. It's my submission that a related person, due to the fact that we deal with a related person abuse, don't need to be included here. The second option is the reasonable person test that must be applied. And the third option is basically the same as option 2, but without the reasonable person test. But it also then inserts the requirement of inspires a reasonable harm to a complainant. So that's the three options before the committee.
Thank you. I have the following hands: Honorable Robert Drachen, followed by Honorable Jala.
Thank you, Chair. Can you go back to domestic violence, Mr. Robertson, the definition of domestic violence? I just want to ask paragraph G, stalking. If that's in brackets, does that mean you're going to delete that? It's in square brackets. Does it mean you're going to delete that? I thought that in the public hearings, there was a huge insistence that the term stalking should remain. So I just want to clarify that your square brackets mean stalking will be deleted or not.
That is correct. Stalking will be deleted. The conduct of stalking is currently dealt with under the conduct that is described as harassment. And the conduct that were previously regarded as defined as forms of harassment in terms of the conduct that constitute harassment. So yes, it's deleted, but it's catered for elsewhere in the bill. It's in line with, amongst others, the Protection of Harassment Act, where we combined all the forms of harassment.
Mr. Robertson. Mr. Robertson.
Mr. Chairperson, can you hear me?
Yeah, we can hear you now.
Sorry, I lost you somewhere. Where?
No, we lost you.
Okay, sorry, let me re-explain.
But you lost us. You are still talking.
Okay, let me I'll re-explain, Mr. Chairperson. Stalking is omitted from the definition of domestic violence. However, stalking is provided for under the conduct of harassment, amongst others, where they stipulate that unreasonable following of a person or accosting a complainant, etc. It is in the first paragraph of harassment, so it is included. It follows a similar trend as the Protection of Harassment Act, where we combined stalking under harassment so that it constitutes all conduct that can amount to harassment. In essence, stalking is a form of harassment. That's why we are deleting it. Thank you.
Thank you very much. Honorable Jala.
Thank you, Chair. Don't move where you were, Mr. Robertson. I just want to come to this C, the one that I was talking about earlier, emotional. It includes emotional, actional, and verbal. But I think this verbal, I'm not sure if maybe it will be, I just feel that we have to include name calling there, because it does work with the issue of psychology, to be specifically on, because verbally, I see that verbal, but verbally it can be in many ways, but name calling is specific because, sometimes somebody will not talk, continually and verbally abuse you, but he can call you a name once and keep on saying that, and that hurts, especially if you don't want that. Sometimes men or women call each other in the very same house because of their head, stupid, you are stupid, you are they even call, sometimes men call women, knowing very well that this is your wife, but you still call your wife. Oh, I see that. No, I'm covered. I can see that. Chair. Let me not waste time. Yes, Mr. Robertson just showed me. Yes, thank you very much. Thank you, Chair. He just stopped.
Apologies, Chair.
Very
Apologies,
strategic.
Chair. Apologies, Chair. Can Mr. Robertson, can you just indicate where it was, where you highlighted? Like on which page, which section?
Sorry, it's on page 14. It's the definition of emotional, verbal, or psychological harm. The option 2 and even option 1. And it's paragraph A of that definition, where name calling is included, or rather retained. It is currently in the Domestic Violence Act.
Thank you so much.
Chair, can I come in quickly? Is that, did we agree on that option? Are you going to remove it or what? Because remember, we are still talking. We are still choosing options. Is it the option that we agreed upon?
We are still coming to page 14. We are still on page 10. I think.
Okay, Chair. No, I'm covered. Thank you, Chair.
Thank you. Honorable Swart.
Thank you, Chair. I want to understand that capital D of the different options with, I like that reasonable test as well, but I'm trying to test the extent of what we are dealing with here, given some of the issues I've raised in the past, such as, and I fully appreciate many people have got various views on discipline of children. We've discussed this issue, but if you were to basically say as a parent, whether you support it or not, if you do this, I would reward you, but if you don't do that, merely expressing the intention to give them a smack, that would then fall foul of HD, which would mean that a complainant, being a child or whoever, could then lay a charge against you for domestic violence, for subjecting a child or even threatening a child, if I understand that correct. So that we just understand what impact we have when we are legislating. And I'm sure my reading of that is it would fall within that ambit, given the broadness. That's the first point. The second point, I prefer going down where you had the reasonable test as a, and those were the different options. This coercive, this catch-all phrase is very broad, and that's when we get to the other issues, it covers almost everything. If you take your first definition of coercive behavior and then this catch-all phrase, it covers almost every possible conduct within a domestic environment. That's why you do need to have an objective, reasonable test. Otherwise, you're going to have every possible minimal conduct that it doesn't amount to domestic violence in the true sense, but legislatively, we could have an unintended consequence. So we need to have some reasonable person test coming in. So those are two issues I'd like to raise, but I'm just concerned about when we are looking, and I'm not advocating any form of child abuse, I'm just saying, would that apply in that situation of a parent-child relationship?
Mr. Roberts.
Mr. Chairperson, yes, it will include conduct where you, amongst others, threaten a child to give him a smack, or that will be domestic violence. But such threats can more or less more readily be accommodated under conduct such as physical abuse, etc. It is wide. If you look at some Australian legislation, they also use a clause similar to clause HD in the legislation. And it's to the effect that exposing, if I remember correctly, is to let the child see or hear domestic violence, or otherwise exposing a child to the after effects of domestic violence, amongst others, where the child have to comfort the complainant who was sexually abused, or where the child, amongst others, experience economic prejudice as a result of economic abuse, or where a child sees a mother with a blue eye. Exposing is probably where you expose a child to domestic violence, where you let him hear or see domestic violence. Subjecting is in any case, to my interpretation of this clause, included in the various other definitions of domestic violence, where amongst others, physical abuse against a child will be covered under physical abuse. So yes, it does expand paragraph HD significantly.
Mr. Roberts, I do think also that we would need to look at this thing very carefully and look at all the unintended consequences, because also you wouldn't want a situation where you criminalize the whole nation on a reasonable chastisement of children. And I do think that we would need to really look at it, because how will parents raise their children?
Point taken, Mr. Chairperson. I did previously pointed out, amongst others, that coercive behavior and controlling behavior is to an extent some of the conduct that every parent use to ensure that the child stay on the right path. I will reconsider paragraph HD and come up with a better solution to the extent where it covers or subjecting a child to domestic violence.
Chair Swart, can I add?
Honorable Swart.
I fully appreciate the intentionally exposing part, but I think it's very important that we as legislators are aware of unintended consequences. And I emphasized this previously, that when there was an amendment brought to the Children's Act to ban parental corporal punishment, the majority party, the ANC and other parties rejected it. We didn't have a constitutional court ruling then in this regard, but I need that we know that there's no legislation impacting that. And at the moment, the Children's Act is being dealt with. So we need to be fully aware of what we are legislating in this regard, so that we do not have an unintended consequence when another committee comes and says, we're dealing with the Children's Act. And it's not to say that this parliament can't deal with it. Previous parliaments rejected a statutory banning of moderate corporal punishment. We fully appreciate, as we discussed last time, that the Constitutional Court has now brought out a ruling in this regard that removes the defense for physical assault, but this we are now dealing with statutory legislation, and as I fully agree with you, we need to understand the consequences of what we'd be legislating. Thank you, Chair. Have we lost you, Chair?
Yeah, remember the chair said he might get thrown off around this time due to load shedding. So just give him a moment while he changes gadgets.
It's 6 o'clock, 3 minutes to 6.
Yeah, he said it's around 6 he might lose his signal.
Where's the Honourable Muffer King?
She must also have lost her signal or taking a nap.
King, where are you?
I think they are all in Gauteng, so the problem
Oh,
is.
Mola's got a signal. I can't believe it.
That is why I don't have a signal. That is why I don't have a signal.
He stole your signal.
Yeah, that is why I don't have a signal. Honorable Swart, are you back?
I am. I'm fine. I made a point, but I see it's almost 6 o'clock, and I think you've already dealt with it, and you've asked Mr. Robertson to look carefully at this issue so that we understand any intended or unintended consequences. But I'm mindful of the time as well, Chair. So thank you.
Thank you very much. Mr. Roberts, also please consult with the Department of Women. I think Mr. Lenders raised the point that you would need to consult with the Department of Women on the definition of mental disability.
Yes, Mr. Chairperson, yes, I will consult with other departments regarding that definition.
Thank you very much, Mr. Roberts. Members, thank you very much. We will meet on Tuesday. I think there is a subcommittee tomorrow, and then we will meet on Tuesday as a full committee. Sia, can you just quickly take us through what will we be discussing on Tuesday and Wednesday?
Yes, Chair, I'm quickly opening up my program, Chair, quickly. My apologies.
Mr. Chair, while we wait for Sia, may I ask you something?
Yes, Honorable Breitenbach.
Thank you. Are we tomorrow? Are we doing anything at all with the traditional courts bill?
I think it will be covered by what Sia is going to say in terms of the program. Yes.
That's fine. Because tomorrow I have a serious difficulty. I have to see my surgeon in a follow-up visit, and Mr. Horn's not available. So if we're dealing with justice stuff, we're going to have a problem.
No, I think it's just a subcommittee.
Thank you.
Sia?
Yes, Chair.
Yes, can you clarify? Yes.
Yes. Tomorrow, Chair, on Tuesday, we will be getting. Remember, we had requested the legal advisor to provide a legal opinion, and which was sent out to members. We will be getting a briefing from her on the legal advice, and we'll be also getting the joint briefing by the SIU and the NPA on the investigation at the Master's Office. And on Wednesday, we will be deliberating on the traditional courts bill, and also getting the briefing that the committee agreed on in terms of the register vis-a-vis the criminal record system at SEPS. That's Tuesday and Wednesday, Chair.
Friday?
Friday, it was reserved for the subcommittee, Chair, and the briefing by the SIU on matters before them. But then, with the engagement we had, Chair, we suggested that because the SIU will be coming with the NPA, we suggest that they maybe we defer that item for our next term.
Honorable Breitenbach, I think you might have received the briefing by the SIU, NPA, and the Hawks.
Yes.
Does it cover the issues you wanted us to discuss by the SIU? Because
very largely, sorry, Mr. Chair, finish, sorry.
Yes, because if not, then it will mean that the afternoon of the 19th will still stand to have that discussion.
The issues that I wanted to traverse are very largely covered. Thank you.
They're largely covered on this one of the Hawks, SIU, and the NPA.
Yes, thank you, Mr. Chair.
So there's no need for that one of the 19th.
No.
Thank you very much.
Chair, Swatya, can I just get clarity when we'll be dealing with the GBV bills again? That's not on the agenda for next week at all, is that my understanding?
It's correct. It's not on the agenda. We still have to consult with all the leaders, but it will be towards the end of the constituency period, because we have to allow space for them to rework and do some research, and also for ourselves to do the constituency period. So we will be working on a comprehensive program that we will present to the, we will do a round robin with all the leaders of the political parties in the committee to agree on a program.
Thank you, Chair.
Sorry, Chair.
Chair.
Honorable Mfuke.
It was Nieuwe-Drucken.
Okay, Honorable Nieuwe-Drucken.
Thank you, Chair. In terms of tomorrow afternoon, there is nothing booked for the gender-based violence bills. So after the subcommittee.
No.
Just to confirm.
Yes, no, there will be, after the gender-based violence, there will be nothing, because you know that you are required to attend classes. And so we have to also allow that space. And also the DA would not be present, so we are allowing that. Thank you very much, members. Thank you very much. The meeting is so yeah.
Sorry, Chair. No, I just wanted to clarify, Honorable Swart, Chair, that we are going to be dealing with an item relating to the gender-based violence next week. It's the issue of the register vis-a-vis the SEBS criminal record system on Wednesday. So it is a matter relating to the bills.
Yes. Okay. No, that's fine. Thank you very much, honorable members. The meeting is adjourned.
Thank you.
Honorable members and everybody who has attended the meeting and those who have joined us at home, thank you very much.
Thank you, Chair.
Thank you.
And thank you.
Thank you, Chair. Thanks to Mr. Robertson.
Thank you.
To the Chair.
Thank you, Chair. Bye.
Thank you.